Good evening. Welcome to our EVE lesson towards the Ghana School of Law Entrance Examination Revision, which we hope to be able to meet regularly as our time permits. So tonight we are discussing constitutional law, and as I have started doing, I try to give you what you call like a question teaser, just to set our mind rolling, or just to excite our interest so that we're able to focus on the topic that we are to discuss. So, for example, we have the question with reference to authorities critically discussed the Supreme Court's divergence on whether the High Court has the power to enforce the Constitution. So that, for example, is a question which actually presupposes that you have understanding of basic aspects of our constitutional law. We come and discuss this question towards the tail end of this lesson. So let us make progress. So the last time we met in constitutional law, we went to the very basics. Now, just in case you missed that discussion, and in the recording there is lesson 2, went to the very basis of constitutional law. So tonight, we want to continue with that. So because we don't have the luxury of time, I will not be able to sort of give a summary of what we did, but we just continue. We can always play back in the lesson. So constitutional supremacy, it is a very important aspect of our constitutional law. And if you didn't appreciate constitutional law at all, it is something that you must take very serious. And what is the idea of constitutional supremacy? It is the basic idea that the Constitution is the fundamental law, that is the basic law, and takes precedence over every legal norm. The Constitution is actually like the foundation. If the laws in Ghana were to be likened to, if you like, a story building, so to speak, then the Constitution is like the very foundation. Just as if you take the foundation, the entire superstructure will collapse. The same thing applies to the Constitution. And that is why we are told in Article 1 of the Constitution Clause 2, in no uncertain terms by the framers, that, quote, this Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void, unquote. So that is quite fundamental. So that is the yardstick which is supposed to benchmark any other law or any other thing in Ghana. So it is something that we should get straight. So for example, if you are writing any answer in constitutional law and you are struggling with appreciation of this simple thing, your marker can actually just jump to the conclusion that regardless of whatever you've written, you are not fit to pass the exams. Now, you may think that that is quite cruel. It's not cruel because you've gone through LLB, right? 3 years, 2 years, 4 years, you have your LLB. Now, a very important aspect of law in Ghana, the constitutional law of Ghana, and for that matter, the doctrine of constitutional supremacy in a written constitution like ours, if you don't understand it, if you don't appreciate it, and it is evident in your response that you don't understand it, you don't appreciate it, nobody will actually sympathize with you. And that is why I would like you to take your revision serious. I've just given you a certain clue. And of course, I don't know those who manage your law school entrance examination, but at least as a teacher myself, I know in a type of examination like selection exams like law school entrance examination, that which can let you be disqualified or be given absolutely or low marks, which will be said that there's no way that you can pass. That is where you have made, if you like, if you're using religious terms, you've made heretical pronouncement. You've made fundamentally, like wrong statement on things which are very basic, okay? So let us keep that in mind. And that is why in Tuffour versus Attorney General, case that we keep coming to, and I think the last time we met in the lesson 2, when we had our very first session in constitutional law, those who were present, I told you that it is one case that if you haven't read it, it's not lengthy. It's very important. You make effort and you read it. And you see, the thing about law is that as you read the material, your subconscious will pick certain important expressions of writing and thinking like a student of the law. If you are doing constitutional law, if you read constitutional law cases, you pick the right language so that when you write your answer will be rich and it will let your examiners smile well on you and give you good marks. So let's keep that in mind. So in Tuffour versus Attorney General, for example, the court made the point that this is the constitutional criterion by which all acts can be tested and their validity or otherwise established. A plaintiff under Article 1(2) of the Constitution, which is the equivalent of our current 1992 Constitution Article 1(2), need not have any community of interest with any person or authority. His community of interest is with the Constitution, unquote. In other words, the court was making the point that insofar as a case relates to constitutionality, whether something is consistent with the Constitution or inconsistent with it, every citizen has got an interest. It does not matter that you cannot show any demonstrable personal interest. So long as it relates to the Constitution, every citizen can take it up. So that was the point being made in the Tuffour versus Attorney General. And it is just a reinforcement of the concept of constitutional supremacy, because the Constitution is the highest law. Anytime that there is evidence or there's suspicion that something is actually not in harmony with it, every citizen, be it a natural person or juristic person, is actually empowered by our laws to go to Supreme Court for determination to that effect. But the question that I gave you, we come back to it later on in terms of the relationship which exists between the High Court and the Supreme Court when it comes to enforcement of the Constitution, particularly so when we know in Article 33 of the Constitution that the High Court has given, if you like, exclusive original jurisdiction with respect to enforcement of the fundamental human rights and freedoms as embodied in Chapter 5 of the Constitution. Then does that mean that the High Court is able to rub shoulders with the Supreme Court when it comes to enforcement of the Constitution? So that is the crux of the question, and we'll come back to that as we move on. There are plethora, there are multitude of authorities as far as the concept of constitutional supremacy is concerned. And if you were asked to explain it with the aid of authorities, if you don't have, you can get more than 10 authorities. If you want even 100, you can get, because almost every case which has gone to Supreme Court as far as interpretation and enforcement of the Constitution is concerned is something which is relevant to constitutional supremacy. And if you wanted to test this observation we are making, you could just take maybe Supreme Court of Ghana law report, or just go to Danish law or Judy law or Ghana law finder, just look up the Supreme Court cases in relation to constitutional interpretation enforcement. And you will notice that there's no case relating to constitutional interpretation or enforcement in which Article 1 or 2 will not be what mentioned, in addition to the very provisions which are directly implicated in that particular case. So you will never struggle to get authorities to support discussion of constitutional supremacy and its implications. So you remember the famous 31st December case regarding the celebration of the 31st December Revolution using state or public resources, and how the Supreme Court actually asserted the supremacy of the Constitution and really proceeded to strike down aspect of policy of the government at the time, which allowed the state to use state resources to celebrate coup d'etat, to celebrate so-called revolution, which the Supreme Court was of the view that it was inconsistent with the letter and spirit of the Constitution, especially the democratic ethos of the Constitution, which is quite evident. Now, another point you have to remember when we are discussing the supremacy of the Constitution doctrine is also Article 2 itself. Article 2 actually amplifies the supremacy doctrine. In what ways? Article 1 plus 2 will tell us that the Constitution is supreme. That is, all laws must be in harmony with it. That is true. Now, Article 2 would actually let that principle bite. And how does it bite? That any person, it gives local standard, or it gives authorization or capacity to everyone who is of the view that anything or a law is inconsistent with the Constitution to go to Supreme Court for a declaration to that effect. And not only that, there are grave consequences. And what are those? Where you have actually invoked the jurisdiction of the Supreme Court under Article 130 in an attempt to enforce the Constitution via Article 2, as we have just cited. Now, when the Supreme Court has actually inquired into the allegations of unconstitutionality or otherwise which you have made, and it comes to conclusion that something is unconstitutional, and then it proceeds to make consequential orders, that is, to give directives which will enable the declaration or the interpretation that it has rendered with respect to the constitutional provisions vis-a-vis whatever is at stake. So where the court has actually ordered that X, Y, Z should be done, and it is not actually carried out, there are grave consequences. And for the first gentleman of the land, and then the second gentleman of the land, as you know, the president and then the vice president, they are even not given immunity from obedience to the Supreme Court when it comes to giving effect to constitutional supremacy. So where orders have been made, for example, and the president or the vice president, as it were, decide not to carry out what the Supreme Court has actually ordered, consequentially having interpreted the Constitution, then Article 2, Clause 5 tells us that such a defiance or such disobedience is a high crime. It is a high crime, which has serious consequences. Yeah, so let us keep that in mind. And for the president and the vice president, not just a high crime. If you look at the Article 2, Clause 4, it is a ground for removal from office. It's an impeachable offense, as it were. So that goes to tell you the enormity of the concept of constitutional supremacy. So that is very important. So it's something that we should actually keep in mind. And that was why in NPP versus Attorney General, the 31st December case, holding 4 of the decision, the point was made by the Supreme Court, and I quote, although Parliament had the right to legislate, every such legislation had to be within the parameters of the powers conferred in the legislature by the Constitution. Because under Article 1(2) of the Constitution, any law found to be inconsistent with any provision of the Constitution should, to the extent of the inconsistency, be void. And once an act was null and void, the president or the executive could be restrained by injunction from enforcing or obeying it. So you notice that I just quoted Article 2, Clause 4 to buttress the point we had made that the supremacy of the Constitution is very important and is a salutary concept or doctrine, such that where it is actually triggered as someone invokes Article 2 and Article 130 and invite the Supreme Court to make a pronouncement on constitutionality or otherwise of certain things, and then the Supreme Court decides to make certain orders, consequential orders, which would enable the interpretation that it has given to be given effect to. If the president, as I have indicated, does not obey it, he can be removed from office. And that is what the 31st December case is also reinforcing. So let us take note of that. Okay, now, very soon, the next time we had the opportunity to do constitutional law, we will discuss constitutionalism, rule of law, separation of powers. And you will notice that these related concepts that we'll be discussing, they actually emanate from this constitutionality, this constitutional supremacy doctrine, especially in the context of our written constitution. It is that which gives meaning to constitutionalism, which gives meaning to separation of powers, rule of law, judicial review, independence review. All these, they are inextricably linked with the doctrine of constitutional supremacy. So it's very important. We have to pay attention to it. There, as I said, we can have over 100 cases of that. So I'm not going to actually run through that. When we are discussing the question that I put over there, I think I've listed a couple of cases, but then I've also given you the clue that anytime you see any constitutional case decided by the Supreme Court, it is definitely relevant to Article 1+2, as well as Article 2. So almost every constitutional law case can be cited to illustrate discussion of the doctrine of constitutional supremacy, assuming you had any such generalized question like that. So let us keep that in mind. Now, the last sub-thematic thing we touch on before we discuss the question teaser and then we are done tonight is the concept of sovereignty. Sovereignty, we are referring to the ultimate power in the affairs of men. So in the country called Ghana, who wields sovereignty? Who is a sovereign? Of course, I don't want to worry you with jurisprudence lectures or philosophy of law, taking you back to John Austin and Jeremy Bentham and Hans Kelsen, but I'll just bring you straight within the context of our Constitution. So if you look at Article 1+1 of the Constitution, you will notice that we are told that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this Constitution. Now, this Article 1+1 is very important, and its meaning will have to be worked backwards to the preamble of the Constitution. So if you wanted to also appreciate the context of Article 1+1, you have to go back to the preamble of the Constitution, in which we, the people of Ghana, we will invoke what we actually stand for, what we are aspiring towards as a society, and say that we are adopting, you take the line, that we, the people, in the name of the Almighty God, we, the people of Ghana, in exercise of our natural and inalienable right to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality, opportunity, and prosperity. Then goes on and on and on. Do hereby adopt, enact, and give to ourselves this Constitution. So Article 1+1 is actually exemplified in the preamble of the Constitution, because we are talking about establishing government, establishing a society. And who has the ultimate power? We, the people of Ghana. And as we move on, you notice that this sovereignty, which is like the ultimate power, which resides in all of us collectively as Ghanaians, from time to time, we need to delegate it to certain agencies or certain arms of the state. And that is why, as we move on, you notice that the judicial power, for example, is an aspect of sovereignty. That is why judges, if someone, your classmate become a judge, he makes an order, you're going to prison, and so on. Not because of he, the person, but because of the sovereignty, the sovereign power of Ghana, which he is projecting. So he is, if you like, just an instrument to project the sovereign power of Ghana. And that is why, if you look at Article 125+1 of the Constitution, we are told, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution, and so on. And then clause 3 says the judicial power shall vest in the judiciary. Now that is an aspect of sovereignty of Ghana. And that is why the coercive power, the use of force to back orders and all that, which is at the disposal of the state, is usually made at the disposal of those who exercise, let's say, such powers, as it were. And then the same thing, you also go to the judiciary, as well, you go to the legislature. Now the legislature too is also exercising aspect of sovereignty of Ghana. And that is why a parliament will legislate and something which was neutral, something which could never give rise to illegality, will immediately become unlawful if you act contrary to that. But prior to the legislation by parliament, it was just a normal thing. And that is an evidence of what? Of sovereignty. And of course, we also come to the executive. we also notice that the executive arm of government, if you look at Article 57, 58, the executive arm of government is also exercising aspect of the sovereignty of Ghana. And not only them, we also have independent bodies. As we move on, we'll be discussing them. Independent bodies of the Constitution. And in various ways, they also exercise aspects of the sovereignty of Ghana. So we take the Electoral Commission. The Electoral Commission is given the power to put in place processes and system for letting decisions be made as to who is going to be given certain authority, who is going to represent us in parliament, and so on and so forth. And when the Electoral Commission, for example, has declared that it is this person who, according to our system and processes, is only elected, that will be it, and that will work. And that is an aspect of exercise of the sovereignty, which Article 1+1 has actually alluded to. We can keep on giving the example on and on. Okay, so we will touch on the question, and then that will be for this session. So the question was that with reference to authorities, critically discuss the Supreme Court divergence on whether the High Court has the power to enforce the Constitution. Now, just a background. There used to be a time, especially you are familiar with the case of Republic versus Maikankan, right? And also the ex parte Akusa, where we had that divided opinion as to if you had a case before, let's say, the High Court, and someone raised a constitutional issue, and the constitutional issue is just, if you like, just an aspect of the case, should the courts go ahead and deal with it, so that if a person is aggrieved, then he can have his remedy by appealing it, or the court should just stay proceedings and make a referral to the Supreme Court and state the constitutional question for the Supreme Court to answer. And then when the question has been answered, the court will use the answer which the Supreme Court has made to adjudicate the case which is before it. So there has been that controversy going on for a long time. And again, we came to have our 1992 Constitution. And the 1992 Constitution has created, as we have seen in Article 2.1, that if you want to enforce the Constitution, you go to Supreme Court. So Article 2.1 and Article 130+1 actually says that if you are seeking to interpret or enforce the Constitution, go to the Supreme Court. Again, Article 130+1A has made the original jurisdiction of the Supreme Court regarding interpretation and enforcement of the Constitution subject to the exclusive original jurisdiction of the High Court with respect to enforcement of fundamental human rights as embodied in Chapter 5 of the Constitution. Again, if you look at Article 41 of the Constitution, it was about duties of all citizens. And the duties of citizens of Ghana include the duty to uphold and defend what? And defend the law. And that actually also lays foundation for the Supreme Court interpretation that, of course, going back even to the Tuffour case, that as far as enforcing or interpreting the Constitution is concerned, every Ghanaian has community of interest. You don't need to have like a personal interest as it were. But So the other point which we also need to think through as we reflect on this question is the distinction between interpretation of the Constitution and application of the Constitution, especially if you look at the case of ex parte Akosa. Now, where there is no ambiguity and so on, you don't have like a rival interpretation being placed on constitutional provisions vis-a-vis any enactment or any particular act. Then interpretive issue does not arise. It's not really about interpretation. Sometimes it's just a matter of applying a rather plain, unequivocal provision to a situation. So that would just be, if you like, the application. So the relevant cases in which the relationship between the Supreme Court on one hand and then the High Court, as far as interpretation of the Constitution or the enforcement of the, of course, not, let me say enforcement, because for interpretation is obvious. We know that it's only the Supreme Court which has the power to interpret. But then the enforcement is concerned. We have like a couple of them. And these are all very, if you are not reading any case, these are some of the cases that you must read. These are some of the cases that you must read. So, ex parte Akosa, Republic versus Maikankan, Edusei versus Attorney General, National Media Commission Attorney General, Abevo and Attorney General, Metenunu and Electoral Commission, Osei Boate and National Media Commission, Fidia against the PUC and Attorney General, Somalia, Belbe and Adamu Dramani, Asari against the General Legal Counsel, Ko and Attorney General, and Kwaku Asari and Attorney General. Now, if you look at all these cases, certain principles emanate from them. So they will bring out the issue of interpretation, application, and enforcement, that these are not necessarily interchangeable concepts. They are distinct concepts. So that what constitutional interpretation means is different from application and enforcement, as it were. So therefore, interpretation of the Constitution, distilling from these authorities that we recited, relates to ascertainment of the meaning, the scope, and the legal effect of the constitutional provision. So what is the meaning of the alleged or cited provision? What is the scope? Or what is the effects of that provision? So these kind of questions go to interpretation. And then application also refers to giving effect to constitutional provisions that are clear and unambiguous. So where you have no ambiguity, the provisions are plain and all that, you just give effect to them because there are no rival meanings or rival understanding being proffered by, let's say, two disputing parties, as it were. Then enforcement. Enforcement relates to compelling obedience to constitutional provisions. Of course, the line between enforcement and application is not a very neat one, and jurisprudentially one may argue that the two are can be used interchangeably, because if you are applying it, can you apply a provision without actually compelling obedience to it? So the two more or less go hand in hand. Now the ex parte Akosa case, which we mentioned above, is very important, or what we may say, it is a locus classicus. As far as the issue as whether a matter raises an issue of interpretation or enforcement is concerned. Now, if you look at the ex parte Akosa case, and you can easily download it on your law finder, so don't be lazy, try and look at it. If you look at the ex parte Akosa case, for example, it will give 4 tests which should be followed in order to ascertain whether an issue you have on hand is one of interpretation or one of what? Enforcement. So that is very important. And these things we are talking about are crucial because if, for example, my cancan will say if it's about enforcement, then there's no interpretation. So the High Court will, for example, apply it. But in the course of time, if we look at the Supreme Court practice, it's increasingly clear that whenever you have like a constitutional issue, you need to make like a referral, except where the particular matter is such that there's a precedent. Maybe the court has already interpreted it. So it is just a question of following a precedent like how it is usually done in stare decisis or the doctrine of judicial precedent. So let us take note of that. So looking at how the acquiescence ratio has evolved through various cases, including Metal Nunu and then the call versus the Attorney General, it would appear in respect of interpretive or enforcement jurisdiction of the Supreme Court and the enforcement jurisdiction of the High Court, the relationship could be outlined as follows. 1, the High Court has exclusive original jurisdiction to enforce fundamental human rights and freedoms in Chapter 5. So when it comes to compelling people to obey, let's say, provisions in Chapter 5, the various human rights, from Article 12 to Article 33, as it were, the High Court alone has original jurisdiction. That is to say that it is the court that you can take up a case for enforcement of human rights for the first time. You can't take it to the Court of Appeal. You can't take it to the Supreme Court. It is the High Court where you can go for the first time. So that is why we say that it has the exclusive original jurisdiction. Then the 2, the Supreme Court does not have concurrent jurisdiction, concurrent original jurisdiction with the High Court to enforce Chapter 5 of the Constitution. So no matter how serious your case may be, so long as it's about enforcement of the right falling under Chapter 5, you must go to the High Court. Even if you ignore that and go to the Supreme Court, you'll be referred back, because the Supreme Court does not have a concurrent original jurisdiction with the High Court when it comes to enforcement of the 5 of the Constitution. The third point to note is that the High Court does not have jurisdiction to interpret any provision of Chapter 5 under the guise of human rights enforcement jurisdiction. Yes, Chapter 5 is part of the Constitution, but then when the High Court is enforcing Chapter 5, and if an issue of interpretation should arise, that is where we have a rival interpretation with respect to the meaning or the scope of particular provision and so on. So long as it is interpretive issue, properly so-called, then the High Court does not have jurisdiction. It will have to make a referral to the Supreme Court. And another point to note is that where the meaning of a constitutional provision is clear and unambiguous, any court any court can apply it. And referral will not have to be made to the Supreme Court. Referral will have to be made where you have ambiguity, where you have a rival meanings being attributed to that provision. But in absence of that, even a district court can apply a plain meaning constitutional provision as it were. Yeah, so the other point to note is that if there's a enforcement action before the High Court and interpretation question arises, as we have indicated, the court will have to state proceedings and make a referral to the High Court. But if you go and read the case of a call versus the Attorney General, you will notice that the controversy regarding the enforcement jurisdiction of the Supreme Court vis-a-vis the interpretive jurisdiction is not really clear. In other words, you can get a line of cases in which the Supreme Court has bled the two, so that both the enforcement and interpretive jurisdiction is actually treated as being at the disposal of the Supreme Court only and not any other court. Again, if we look at the provisions that, the cases that we listed over there, another impression one also get is that despite the exclusive jurisdiction of the High Court in enforcing Chapter 5, the Supreme Court, in the course of exercising any of its jurisdiction, can apply any provision in Chapter 5. So let's get that clear. Yes, the Supreme Court does not have original jurisdiction with respect to Chapter 5. It is a High Court which has got exclusive original jurisdiction. Nevertheless, when the Supreme Court is interpreting the Constitution under Article 2 and then Article 130, don't forget that Article 2 tells us that the Supreme Court may give orders, consequential orders, and so on, which it considers necessary in order to give effect to the interpretation that it has propounded. So if that will, for example, include the Supreme Court making certain orders, which will have the effect of enforcement of maybe a right under Chapter 5, so be it. So let us pay attention to that. And as I said, have to go and read the cases that I have suggested. So unless there's a question, otherwise we end the class here, and then God willing, if there is time, we'll meet tomorrow.
A question.
So if you, Charles, you've muted yourself. Yes, go ahead. Let's hear you. Charles, are you talking? Okay, it's not.
The line between. Hello.
Yes.
I was asking of the line between the interpretation and enforcement, especially with respect to parliamentary elections. Case in point is the Article 93. Sorry, 94. I read the case of J.H. Mensah.
Mr. Attorney General.
No, I mean, it's J.H. Mensah versus one Michael Asantu, so in Senyane.
Okay.
Where the guy, the applicant alleged that J.H. Mensah was not having a house or was not resident in the Senyane constituency then, and so was not qualified to stand as a parliamentary candidate. But the
Okay.
Supreme Court rejected and said it was a parliamentary election petition, which was dressed as an interpretation issue.
Okay.
And so it should go back to the High Court.
Okay.
And then the other case, the Asinov case, where the lawyers for the MP said,
Which
I
case?
mean,
Which case?
the Asinov,
A send off. Okay. Is it
yeah,
Quay's, what is the name?
Ajayi question,
Quay's, yes.
where the lawyer disputed and debated on when will you say a person is an MP, because the provision say a person is not qualified to be an MP if you own allegiance to another country other than Ghana. So they were debating when will you say the person has become the MP, at the time he filed, at the time he was elected, or at the time he was sworn in. But the trial high court decided the case, even though the other lawyer protested there was an interpretation issue that he needed to refer to the Supreme Court. So I want to know, at what point will you say this is an
Okay, you know
interpretation and this
something.
is an enforcement?
Some of these cases, they've not completely exhausted the judicial journey. And I stay off pronouncing on those matters for obvious reasons. But the point, I think, coming back to your question, without like the examples, is to when can we be sure as whether the issue on hand is purely interpretive or it is enforcement. I think that is what I get from you. Yeah, so the interpretive one, and from the various principles that we distill from the line of cases, is where you have ambiguity, that is, the meaning of a provision is not clear, or there are rival interpretations. That is to say that one person is saying that if this particular provision, you construe it this way, this is the proper meaning, and this is the proper import of it. And again, it may also be that if you know, of course, sometimes you may also have like a very, what you call the unarticulated policy issues, which are also embedded in some of these interpretive issues. And that is why we often say that the Supreme Court is a policy court. You see, the Supreme Court is not just ordinary court of law. It is also a policy court. And that is why you go to some jurisdiction, they even have what they call the constitutional court, who deals with only constitutional policy and things like that. And then we have like the normal, the normal appellate court and so on. So we have to appreciate that particular important and special role of the Supreme Court as far as policy matters are concerned. And you cannot often take policy issues out of some of these very important interpretation issues which also come up. And that is why if you like philosophy of law, you begin to appreciate that when it comes to interpretation of constitution, it's not just ordinary exercise in statutory interpretation. There's much more at play than what we usually know with respect to ordinary statutory interpretation. So let us keep that in mind.
Thank you, sir. Then lastly, I beg your pardon, my lord.
Okay.
We also learned that where your right as an individual is affected, the forum is the High Court.
Yes.
But where the rights that are affected is more than one individual, Then
Yes.
the forum is the Supreme Court. I don't know
Okay.
whether this indicator is also a sound one.
Okay, let me give you. Remember this case, Nana Ampofweje, this pit latrine case. Remember that? Do you remember the pit latrine, the nice soil? That case.
Yes, sir.
Do you remember that?
Yes, sir.
No, that case, for example, if you look at it, one will argue that it has to do with personal dignity and things like that. So it's quintessentially a human right matter. Nevertheless, as you rightly observed, it was not just a matter where a person was complaining that my human right has been violated. No, if you go and read that case, you will notice that Nana, I think that lawyer, who took it up as
Ajay Ampofo. It's Ajay Ampofo.
Thank you. Yeah, who took it? Yes, thank you. Who took it up as if you like, a public interest litigation? Was just bringing up the issue that yes, if you look at the carrying of nice soil and things like that and so on, it is something which is demeaning to human dignity and all that. And if you look at the constitution, it doesn't sit well. So that was something. Yes, ordinarily it's a human right, but it was not a human right which a person was complaining that I was the immediate, if you like victim, but something for the entire society. And that one is different from what is contemplated under Article 33 of the Constitution. So that one becomes, if you like, a matter of interpretation, a matter of enforcement, as it were. Reginald?
Yes, sir.
Your hand is up?
Sorry.
No problem. Okay. Right, then have a good night.